Today's webinar focuses on the benefits of convergence of IP systems for cross-border trade. Regional integration in intellectual property matters has been on the policy agendas of CARIFORUM states for quite some time, and including, for example, the CARICOM Treaty of Chaguaramas, which sets the stage for the single market and economy, Article 66, the regional integration provisions provided within the CARIFORUM EU EPA, in particular Articles 133 and 141, and also have been reaffirmed in the WIPO ministerial level meetings most recently held in 2018. And so, this webinar kind of fits within that context, within that staging. We have put together an interesting program for you today. We will hear from the experiences of a range of different organizations as well as actors from the private sector. We have with us as speakers Ms. Helen Moss, who is a legal consultant from a lawyer and legal consultant from Barbados, Ms. Rachel Jones, and she is from Scotland, Mr. Charles Pundo, Head of Formality Examination Department, ARIPO, the Africa Regional Organization, Intellectual Property Organization, Mr. Andrei Sekretov, who is the Director of International Relations from EPA, who's based in Russia. We will have Mr. Ignacio de Medrano Caballero, who is Head of the International Cooperation at the EU IPO, and we will also have Alessandra, who we just heard, presenting as well. As mentioned by some of the previous speakers, the objectives for this event sort of fits within the context in general in terms of the CARIFORUM Directorate as well as the CarIPI's project. This event achieves one of CarIPI's key objectives, which is to raise awareness of intellectual property issues among policymakers, in particular national EPA coordinators and relevant ministries on the importance of intellectual property rights and in particular the international systems for regional harmonization initiatives, especially in relation to transnational trade facilitation. More specifically, it will raise the awareness of participants today in relation to existing regional and international convergence efforts, as well as the positive impacts of regional harmonization of IP systems for trademarks, or rather the harmonization of IP systems for trademarks, and which have a positive effect on trade in IP-rich goods and services and overall economic development. Another objective is to allow for you to hear firsthand how micro and small businesses can benefit from such systems. So therefore, examples from regional IP organizations as well as from the private sector will be heard. Without much ado, I will invite Ms. Alessandra Mer, who just gave the opening remarks, to speak to us on how the CarIPI project supports these regional convergence efforts. Alessandra, welcome, and the floor is yours.
Thank you, Wendy. We were also asked for some EPA coordinators who might be newer to this project to explain briefly its background. So I would like to recap that this project, also as Mr. Percival mentioned, is one of the actions under the EPA support program. This specific action addresses all the 16 countries, including Cuba. It is implemented by the EU IPO, and initially the duration should be 4 months, ending in the end of 23, but it will probably be extended. And also in terms of budget, it was to be 3.2 million, but as Mr. Percival mentioned, we would add some funding. We will. It is not signed yet, but extend in terms of funding and time this project. In terms of governance, the project is under the EPA support program steering committee's direction, and we have also a technical committee, or called a sub-steering committee, in this case composed by the European Commission delegation in Barbados, the CARIFORUM Directorate, the EU IPO as an implementing agency, as well as the 16 CARIFORUM IP offices as the technical counterparts here in this project. We had one physical meeting before the pandemic started, as the project also started not long before the pandemic. The overall objective of the project is to contribute to regional integration of CARIFORUM into the world economy through strengthening the enabling framework that stimulates innovation and competitiveness of the private sector, particularly to further upgrade and harmonize the IP systems, the systems for IP creation, protection, administration, and enforcement, in line with the EPA provisions, and to contribute to regional integration in IPR. We have 4 expected result areas. One is to increase awareness of the value of innovation innovation and IP to economic and social development among policymakers, private sector, and general public. A network of strengthened and more efficient IP institutions delivering high quality IPR administration and enforcement services, benefiting small enterprises in particular. As well, an enhanced legal framework and policy framework in the area of trademarks, designs, and GIs in particular, facilitating the participation in global protection systems in compliance with EPA provisions. And lastly, but not least, improved capacity of the productive sector to create, protect, utilize, commercialize, and enforce their IP rights, thus stimulating innovation and new business models. As a general overview, so we are implementing activities during the 4+ years, up to 5 years probably, on these 4 activity clusters. And some examples of things that we do are events and workshops, studies, and data collection. Now, on the second work package, we conduct a lot of training for IP offices, staff, the examiners, to discuss the process of registering trademarks, designs, GIs, and so on. We also work on IT tools and databases which will contribute to increased transparency in this area. As you know, one of the first things you need to know is if an IP right is already protected, taken by someone. So this specifically will be one of our targets, to get the databases online, as well as we have some activities with enforcement agencies, including, for example, customs, judges. And then under the third work package, we focus on WIPO treaties, where countries decide to join the international IP treaties. We provide support, and as well we work on other areas of harmonization of law and practice, as we see today. Thirdly, on the private sector, the fourth work package focuses and actively involves private sector businesses, providing training and hands-on technical support. So the copy of some of the articles that the project can target the most from the EPA. As one project also, we cannot tackle everything, so this has been singled out what we certainly can target, start to work on at least. Today, the focus is on regional integration in the IP field. So we see that in the EPA, it is mentioned twice, but also in other policy agendas, specifically the Treaty of Chaguaramas, but also other events organized by WIPO at ministerial level. Regional integration has been recognized as potentially being very beneficial to the region, which currently in the CARIFORUM, there are 16 countries, 16 different laws, and 16 different IP offices. Probably firms are facing different situations when they try to trade and protect their trademarks or designs or patents outside of their territory. So in the EPA, it states that both parties will increase action at regional level with a view to providing a regulatory and policy framework conducive to fostering innovation. Also, that further steps for deeper integration in the respective regions will be considered, including laws and regulations, even up to the point to see if more regional intellectual property rights could be created, and to move to a harmonized level of IP protections in their respective regions. But actually, so what are the reasons behind the potential solutions and the benefits? This is what we want to be discussing today, and shedding a bit more light on why regional integration can benefit the CARIFORUM region and how it has benefited other regions. For some reasons behind, we all know that intellectual property rights are territorial rights. So if someone has his trademark and his patent protected in one country, doesn't protect you from being infringed in another country. If you start to trade across borders, you will have to start securing your rights also across borders. So the rights are territorial, but businesses and brands are ever more global, particularly now with COVID also moving more online, probably gives bigger exposure to any innovation and brands created at the local level, and it doesn't stay just local anymore. Different legal frameworks, however, and different procedures, different forms and practices, different costs of protection create barriers to legal trade, particularly for the smaller firms who can get lost and not know what to do when they actually want to trade in other countries in the region or internationally. Then several international agreements that are administered by WIPO, for example, aim to generate create a minimum common ground and create also some global protection systems. We will hear on other occasions as well about the Madrid system for the international protection of trademarks, which currently in the region, Antigua and Barbuda has been a member for 20 years, and Trinidad and Tobago just joined now. And other than that, 122 countries in the world that are part of this system, including the US, China, and most of the big companies. So this facilitates when a country from CARIFORUM joins this treaty, it means that there has taken place some alignment of the law and practice on trademarks. Most importantly, that it facilitates companies originating in your territory to extend a protection for their mark outside and designate the countries in which they need to trade and need their trademark protected. Then there is similar systems for designs and for geographical indications and for patents as well. So this is one level, but then there are also regional IP rights and systems that could be envisaged and that have been mentioned in these policy documents or in the EPA. They are also gaining importance. So we today will show you some experience from Africa. There are two main organizations at this moment, ARIPO and OAPI, and we will have ARIPO here today. Europe, there is Benelux office that groups 3 small countries, Belgium, the Netherlands, and Luxembourg. And then there is the EU IPO that groups all the countries in the EU where you can obtain a right that is valid throughout the 27 member states, and as well as EPO, who still has more member states for patents. In Eurasia, well, there is the EAPO, which we will hear afterwards, as well, a grouping of several countries, including Russia, who also decided to create a supranational right to facilitate trade. How CARIPI contributes to convergence objectives is that we support CARIFORUM states IP offices to offer more services online in the same form as many other countries in the world already do. So there exist specific databases created by the main organizations. EU IPO already provide and facilitate searches of already existing rights. In this case, the EU IPO can offer to integrate into some of these systems called TM Class, TM View, Design View, Design Class, and to create also regional interfaces. This is like just one example, but we could speak about this a few hours to explain the details. But in the area of trademarks, for example, classification is one issue that is important and in the moment when you register a trademark, you have to indicate which goods this will apply to, the protection. So there are a lot of different approaches in the classification that could be harmonized relatively easily, or at least could be published each country what it accepts in terms of terms for trademark protection. Efforts to join or implement international treaties as well we are supporting. For example, we have developed some guidebooks for those countries that joined the Madrid system on the international protection of trademarks. For now, Antigua and Barbuda and Trinidad and Tobago, and these can be extended to other countries and in the end very align the practice and the information available in the different countries. Also, we can support with the implementation of actual registration frameworks. So for those countries who don't have a working framework in place, like for plant varieties, there not yet every country in CARIFORUM does have a framework to protect plant varieties. So we could help already the Dominican Republic after they passed the law to implement, actually to train the examiners and to practically make it possible to register plant varieties in their country. And now that St. Vincent and the Grenadines also joined, we could continue with that, and hopefully many more countries in the region providing guidelines on how to examine and training examiners, for example. This is just a picture from the guides and the work done for the Dominican Republic. Also, we can support IP offices in aligning their practice on aspects not dictated by the law. There are practical things that are left to interpretation and to each office developing their own practice. So where we start to exchange on the technicalities of trademark and design examination, for example. There will be manuals, guidelines, and hopefully commonly accepted practices. And we also support in modernizing IP laws where the countries decide to update their laws. We are working, for example, on a draft model law on GIs. There will be a second regional meeting about this. And if everyone, for example, or some countries would use this draft model law once they want to update their GI frameworks, then the hope would be that they are further aligned in the future. Then we could also, and we will, support deeper regional integration efforts. So if there is any real policy will to create regional rights or competencies, we are are sharing know-how, like today, can provide technical assistance or studies, for example, to help you realize this. Now, that's all from my side for now. We have a website, and for those who don't know yet, would follow us on the social media as well. Without further ado, I would invite you to hear the experience from around the world from the interesting speakers we have today. Thank you.
Thank you, Alexandra. We can move on to our next speaker, who is Ms. Helen Moss. She will be giving us the experience of the CarIPI business trading across the region. Ms. Moss is an attorney at law who specializes in intellectual property, corporate and commercial law. She has worked as a corporate attorney with companies in the CarIPI region, and in the past she has worked as a consultant and also as a deputy registrar of the Barbados Corporate Affairs and Intellectual Property Office. She holds a bachelor's degree, a bachelor's of law degree, and a master's in intellectual property. Helen, welcome, and you can start your presentation.
Good morning. Thank you for having me. So I'm going to be speaking today on the experience of CarIPI businesses trading across the region. I am going to speak from the perspective of a larger company in Barbados. I would have spent the last 12 years working for Goddard Enterprises Limited. So I'm going to give you a little bit of the background of Goddard's. I'm no longer there. I'm now in private practice, but I was there up until around the middle of last year. So I'm going to go through a little bit about what Goddard's does and how widely they trade. If you are interested in more, all of this information is publicly available on the Goddard's website because it is a publicly traded company. So all of their annual reports are available, list of their brands, that kind of thing. So as I mentioned, I spent 12 years as one of the in-house legal counsel at Goddard Enterprises Limited. I'll call it DL. And it's a publicly traded company which was founded in 1921. They're actually going to be celebrating their 100th anniversary in October of this year. So GL was originally a meat and grocery store which operated in Bridgetown, which is the capital city of Barbados. Today it has interests across several industries, including airline and industrial catering, real estate, packaging, biotechnology, property rentals, meat processing, bakery operations, the manufacture of aerosols and liquid detergents, and the retail of automobiles and building supplies. And it also provides shipping agent and stevedoring services. And on the left of the screen, I'm just showing you one of the more popular Goddard's brands with Beep, and I'm showing some of the disinfectant sprays. Beep is owned by Goddard's subsidiary in Barbados, McBride Caribbean Limited, and its products are distributed in 26 markets in the Caribbean, Central, and South America. Through its subsidiary and affiliated companies, GL operate in the countries listed below. I'm not going to go through the whole list, but it's almost the whole of CarIPI and several territories in South and Central America, in the United Kingdom, in the US, and in Canada. So at GL, I provided advice and services primarily to its affiliated and subsidiary companies operating within CarIPI and exporting products to CarIPI member state. Where GL does not have a physical presence within CarIPI, for example, in Dominica, the Dominican Republic, and St. Kitts and Nevis, it doesn't export its product. I'm going to talk a little bit about trademarks. Typically, a large Barbadian company will have a number of trademarks which are registered throughout CarIPI. So these trademarks may be registered in as many as 10 to 12 member states. And they're also often registered throughout Central and South America and in the US. And I think the most convenient and cost-effective way to register the trademarks would likely to be file a single application under the Madrid Protocol, which we've talked about before, for each trademark. And such an application would designate the member countries where the trademarks would be registered, and one set of fees would be paid. However, Barbados is not a signatory to the Madrid Protocol, so this was not an option for us. And over to the left, I'm just showing you some of the more popular, again, GL trademarks, E, Pharmastrace, and Bot, which are widely distributed throughout CarIPI. So what are the options? One option is to instruct a global intellectual property law firm overseas to register the trademarks in Central and South America, the Dominican Republic, and the US. And these global intellectual property law firms have relationships with other IP law firms throughout the world, and then they can in turn instruct these law firms on behalf of the various GL companies to have their marks registered. So using a global IP law firm addresses a number of issues. There's typically a large volume of work to be undertaken and limited resources in the offices locally, in our offices locally. There's often a language barrier. So for example, if we were registering marks in Central and Latin America, quite often there was a language barrier there. And then obviously there's a lack of knowledge of what is required in each of these territories to register the trademark. But you do have to bear in mind that hiring such a law firm adds a significant layer of cost to what it would cost you to register each trademark, because you're paying them for their services and you're also paying the individual law firms in each of the territories where you're actually registering the mark. Now, for the marks registered within CarIPI, you can establish relationships with law firms in each territory where you want to have the marks registered. So in most of these territories, there is no language barrier. There is a basic understanding of the application requirements because it tends to be very similar. similar, and the information that you have to provide and the forms to be completed are also very similar. But there are, however, a number of challenges which I'm going to address in the next couple of slides. And just wanted to make the point that although the requirements throughout the CARIFORUM territories tend to be very similar in the Caribbean, I'm sure elsewhere, but if you're admitted to practice in Barbados, so for example, I'm admitted to the bar in Barbados, even though there may be very similar requirements in, say, St. Lucia for what is required, I'm not qualified to practice in St. Lucia or to advise on the laws of St. Lucia unless I'm also admitted to the bar there, which, you know, I'm not. So you do have to engage attorneys in each of these territories. So what are some of the challenges? The first challenge is, as I mentioned, you have to instruct a different law firm in each CARIFORUM territory where an application to register a mark is to be made. And as I also mentioned earlier, you're typically instructing you typically want to have your marks registered in about 10 to 12 of the CARIFORUM member states, maybe all. So in that case, you would need to have an attorney. You need to have 10 to 12 different law firms working for you to register the trademark. The requirements to register the trademarks tend to vary between the territories. Now, you can prepare one set of instructions for all of these law firms, sort of saying what the mark should look like, what you want the mark to be registered for, in what class, and who the mark is to be owned by. But because the requirements are different, there's always little differences between the territories. You're invariably going to have a lot of back and forth, giving additional information, explaining things, gathering more information. So it is quite an involved process. Another challenge is that, in order to register a trademark, you're typically required to authorize an attorney to act as your agent in the territory where you want to register the mark. And there's also different application forms that you have to complete. You'll find that the information required on the authorization of agent form and the application form is very, very similar. They want to know what goods, what class, what the mark looks like, but the forms themselves are all very different. Well, I wouldn't say very different. The forms themselves are all different. There's no one form that you can use across the territories. So you have to make sure you have your correct form for each territory. Also, you tend to find that the form of representation of the mark, so the actual picture of the mark that you have to provide, it varies. Do they need printed copies? Do they need it in JPEG? What size do they need? What color do they need? So all of that is also very different, although ultimately they just need a representation of the mark. Another challenge is that there tend to be differences in the signature requirements, so who can sign and who must witness the forms. Some territories, they require directors of the companies owning the trademarks to sign. In others, they require a corporate secretary to sign, and that would make my life easier because I was often the corporate secretary for all of these companies. In some territories, they require signature before a notary public, which can be a bigger deal because you have to go to the government office where you're required to sign before the notary public. Others allow for signature before a JP, and there are a lot of JPs, so typically you have one in the office. And the next point I addressed is that when the trademarks are registered, there are invariably differences in what was intended to be a single trademark registered across several territories. And the reason for that is because territories have different ways in which they interpret the NIS classification. So although the goods will be similar, they're going to have you list your goods in a different way. Some territories will require disclaimers for descriptive words. Other territories don't require disclaimers or have a different interpretation of what is descriptive. So then maybe your physical mark looks slightly different. So what would be ideal is if we had one trademark registered across 12 territories for the same goods and services. That would just make our lives a lot easier. And often the differences are just small nuances. It's not huge difference, but sometimes they can be quite significant. Last issue that I address is that the territories take a very different amount of time in how long it typically takes to have a trademark registered. It can take anywhere, in my experience, from about a year to about 5 years to have a mark registered. Some territories will count the beginning of your registration period from your application date. Other territories, if they know it took them 5 years to register your mark, will count the beginning of your application period from the registration date. And then just having the different dates to registration means that although all marks are typically valid for 10 years, I think some are 7, you're going to have very different registration dates for one trademark across 12 territories. So now you're trying to track trademarks that are owned by dozens of companies across 12 countries. They're different trademarks and they all have different renewal dates. I mean, there is software that you can use to help you track it, but of course that's an added cost and it just makes everything a lot more difficult. And just making the point that the difference in the length of time that it takes to register the mark, so the 1 year versus the 5 years, has nothing to do with whether there's an opposition filed, because obviously you would expect that to lengthen the period, but this is just a straightforward registration. So those are the challenges. I'm just going to talk briefly about smaller entities. So before I worked for Goddard's, I worked for the Barbados Intellectual Property Office, known as CARIPI. As I mentioned, large companies have a number of challenges, and obviously they tend to have greater resources. So smaller companies experience even greater challenges. When I was the acting deputy registrar, I would have small business owners or individuals come into the office for advice on registering their trademark. We could actually guide them, help them with with the applications, and they could actually make the applications themselves without having to go through an attorney in Barbados if they chose not to. But I often had them say, okay, but I want to export my t-shirts, for example, to Jamaica. How do I register the trademarks in Jamaica as well? Unfortunately, that was not something that we could help them with. They would have to engage an attorney in Jamaica to act on their behalf, and that was often a huge deterrent on costs, but also just the process. Another option would be to engage an attorney in Barbados, who would in turn engage an attorney in Jamaica. But again, that adds another layer to the cost of having the trademark. And that is all. If you have any questions, I'm happy to answer them.
Thank you very much, Helen, for your very interesting presentation on what it's like to actually, as a business, to conduct trade within the region under the current intellectual property system that we have within the region.
You're welcome.
If there are any questions for Helen at this point, or if any of the participants from the other IP offices or anyone else would, can share an experience that they've had in this regard, you can do so at this point. And I don't see any raised hands as well in terms of questions. Oh yes, there is a question from Malcolm.
Good morning, everyone, and good morning, Helen. How are you? Glad to see you after all this time. I wondered if you could say a little bit about enforcement of the trademark. If there's an infringement, how do you detect it in a different jurisdiction? And you had challenges in proceeding with the action against infringement in the other jurisdictions.
Right. I would say luckily we haven't had too much of a problem with infringement, and we tend to have people on the ground in most of the jurisdictions. So in terms of detecting it, just because Goddard's tends to have a presence in almost all of the CARIFORUM territories or good relationship with its distribution company, and detecting hasn't tended to be a problem. And in terms of infringement, we really, luckily, I really can't think of any major issues that they have had. So no, we've been lucky in that regard.
Thank you very much, Helen. At this point, we will move on to our next speaker, who is Mr. Andrei Sikritov, who is the Director of International Relations at the Eurasian Patent Organization. He's in charge of the International Relations Department at the EAPO. With his background in automation and in finance, he joined the Eurasian Patent Office as a patent information products expert in 1999. In his career in the office, he has been involved in administration of the development of various Eurasian patent information products and services, as well as implementation of international cooperation projects in the area of patent information. For several years, he was in charge of patent information quality in the Eurasian Patent Office. Mr. Sikritov, thank you for joining us and welcome. You can start your presentation.
Thank you very much. Good morning to the participants in the Caribbean region, and good afternoon to our EU IPO colleagues and CarIPI colleagues. And thanks for this introduction, and thanks for the opportunity to present the Eurasian Patent System. So the Eurasian Patent Organization is an international intergovernmental organization with its headquarters in Moscow, Russian Federation. The main treaty, international treaty on which the organization is based is Eurasian Patent Convention. It was founded in 1995. It came into force in 1995. It was adopted in 1994. And the main objective of the creation of this organization was the administration of the Eurasian patent system for the legal protection of inventions. For more than 25 years, the Eurasian patent system was dealing only with one IP subject matter, inventions, but now it is changing. We will have industrial designs very soon, but I will speak about that closer to the end of my presentation. This slide shows the list of our member states. We have 8 member states. As you may maybe notice, all of them being former Soviet Union republics. And I think that was the main reason of the creation of the Eurasian Patent Organization in the 90s, last century, because when the Soviet Union collapsed, all the resources of the Soviet Union states state IP office, they pass to the Russian Federation IP office, while all other former Soviet Union republics, they had to build their own IP systems almost from scratch and build their national IP offices almost from scratch. So there was a real need to cooperate in order to provide protection for inventions on the territories of these former Soviet Union republics. But time has shown that this was not a temporary solution. The services of this patent system are in good demand, and the system has good prospects to develop further. Our 8 member states, they do not form any political union like EU in Europe, but the only formation that we have in our region is the Eurasian Economic Union. So 5 member states of EAPO are also members of the Eurasian Economic Union. But if we speak about our 8 member states, this experience of cooperation is quite unique in the area of intellectual property for our region, I mean. So the organs of the Eurasian Patent Organization are Administrative Council and the Eurasian Patent Office. Administrative Council is made up of plenipotentiary representatives of all our member states, and the Administrative Council, it deals with policy matters, to a certain extent with legislation, approves the EPO budget, it elects EPO president, and it supervises activities of the Eurasian office. While the Eurasian Patent Office is an administrative and executive body of EPO, representatives of all EPO member states they form the staff of the office. The office is located in Moscow. So the main duties of the Eurasian office on the territories of these former Soviet Union republics. But time has shown that this was not a temporary solution. The services of this patent system are in good demand, and the system has good prospects to develop further. Our 8 member states, they do not form any political union like EU in Europe, but the only formation that we have in our region is the Eurasian Economic Union. So 5 member states of EAPO are also members of the Eurasian Economic Union. But if we speak about our 8 member states, this experience of cooperation is quite unique in the area of intellectual property for our region, I mean. So the organs of the Eurasian Patent Organization are Administrative Council and the Eurasian Patent Office. Administrative Council is made up of plenipotentiary representatives of all our member states, and the Administrative Council, it deals with policy matters, to a certain extent with legislation, approves the EPO budget, it elects EPO president, and it supervises activities of the Eurasian office. While the Eurasian Patent Office is an administrative and executive body of EPO, representatives of all EPO member states they form the staff of the office, and the office is located in Moscow. So the main duties of the Eurasian office are listed on this slide. The office conducts patent search, examination of Eurasian application, grants patents, publishes Eurasian patent information. It maintains Eurasian Patent Register, records transfer of rights, pledges of rights, and it collects annual fees and then distributes them to our member states. This is, I think, one of the most important slides in my presentation. It describes the unitary effect of the Eurasian patent. The Eurasian patent is valid in all our member states directly after grant. There is no need for some additional actions like provision of translations into national languages or validation or examination on national level. It is valid directly after grant in all our member states. But when time comes to pay annual fees for the first time, annual maintenance fees, then patent owner may choose member states for the maintenance of Eurasian patents. So if they pay maintenance fees for a particular state, the patent will remain valid in that state. And if they do not pay fees for a particular state, the Eurasian patent will lapse in that state. So benefits for applicants are quite clear. They may cover all eight member states with one patent based on only one application, filed only in one language. The official language of the Eurasian Patent Organization is Russian. pay only one set of fees, have only one examination process, and which is also important from the financial point of view, they need only one patent attorney to cover all 8 states. Now, all our member states, they have their own IP systems, sometimes very advanced IP systems, and at the same time, they treat granted Eurasian patents same way as they national patents. For example, liability for infringement of Eurasian patent is the same as liability for infringement of national patents. And enforcement in that case is provided on territorial basis. This slide summarizes all the procedures related to Eurasian patent system, and they are grouped on the level of centralization, let's say so. The whole patent procedure, including grant, is unitary. Opposition procedure used to invalidate Eurasian patent and performed by the Eurasian office is also unitary. Some procedures are centralized, like payment of annual maintenance fees, transfer of rights, limitation and surrender of patent, extension of patent term, which can be done in respect of some kinds of inventions, and invalidation, licensing and enforcement, they are provided on a territorial basis. Just a short note about financial aspects. Our member states do not make any contributions. Our organization is self-financing, and moreover, maintenance fees that we receive, they are later distributed. 80% of patent maintenance fees are distributed among our member states in which the patent remains valid, and they can use them, for example, to support the national patent systems, to finance some projects in the national patent offices. This is quite a common practice. Some words about our statistics. As you can see from this slide, the filing of Eurasian applications is quite stable year by year. Even in 2020, when we all saw massive effects in economic due to the pandemic, we only had about 3% drop, which we think quite a good result. This is a distribution of top applicant origins in the last year. As you can see, the US applicants are leaders by far. Then they are followed by applicants from Russian Federation. And there are 2 more countries in this top 12, I think, list with the bars in red, Belarus and Kazakhstan. They are also from our region, members of the Eurasian Patent Organization. I'm not going to cover in detail our Eurasian patent procedure. I just wanted to note that the Eurasian patent is granted on the basis of international type patent search and formal examination, and the decision to grant or to refuse to grant is taken by a board of 3 examiners, nationals of different member states. So we always say our patent is a strong patent or legally solid patent. And just one more example of the balance between centralization and nationally based procedures. This is invalidation of Eurasian patent. So there are 2 ways to invalidate Eurasian patent. One is an opposition procedure. It is done by the Eurasian office within 6 months from the patent grant date. It's on the right side of this scheme. And the decision, the outcome of this procedure, it is valid for all APO member states. And there is another way to invalidate the Eurasian patent. It is nationally based way. It is done by a national court or other competent authority in each of our member states. There is no time limit to file this kind of opposition within this procedure, but the results of the outcomes of this invalidation procedure, they are valid only for this particular member states, but not for all APO member states. And now some words about some very great happenings that we are expecting to have in just a week. On the 17th of March, the protocol to the Eurasian Patent Convention on the protection of industrial designs will come into force. It was adopted and signed in September of 2019. It is ratified so far by 6 APO member states, and we hope that our office will launch the operations in the second quarter of this year. I think I will skip the slide. The idea was that it is very important to decide on on the levels of legislation, in this particular case, the legislation on industrial designs. So we have 3-tier structure. One is for the protocol itself, which is not easy to change. Then comes the level of patent regulation stated on fees, which can be changed and amended by Administrative Council. And another tier is for guidelines, rules, etc., which is adopted by the Eurasian Patent Office. So what's the difference of APO design system if compared with APO patents for invention system? It will be even more unitary. So it will not be possible to select states for maintenance of Eurasian patent. It's the requirement to be compatible with the Hague system, international Hague system, but there will be instead a procedure of patent term extension, but it will be unitary for all our member states. And the patent term extension fee will be unitary, and then it will be set by the Eurasian Patent Office. We will also have a pre-grant opposition procedure, which is also quite unique, I think, in the IP world. But, well, generally, in many other aspects, it will be more or less the same as the Eurasian patent system dealing with inventions. So my conclusion is quite simple. A regional system is beneficial to all. Applicants, they receive legally solid patents, and this is for them much easier and cost-effective coverage of several countries simultaneously, which provides easy access to regional and national markets. It is also beneficial for national IP systems and IP offices. As I said, they make use of maintenance or in future term extension fees. They may use common IT tools created by regional office. They also participate in regional assistance and cooperation programs, trainings, and they may always obtain advisory support if they need it. And of course, regional systems are beneficial for national economies because it boosts the number of inventions and designs protected. Several years ago, we made a comparison of number of patents valid in, for example, in Kazakhstan, which is a party to Eurasian Patent Convention, and in Uzbekistan, which is not a member of APO. So the difference in the number of valid patents was, I think, from 7 to 9 times. So this is really beneficial for national economies because valid patents, they open doors for innovative technologies, new products, and fosters development of trade. Thank you very much for your attention, and I look forward to your questions.
Thank you very much, Mr. Sirkatov, for your very engaging presentation that sort of brought a perspective for the region in terms of what it's like to actually have a regional system in place. So thank you very much for that. Do we have any questions at this point for Mr. Sirkatov, or do we wait until the end of the presentations? Okay, there's no questions in the chat at this point, and there are no raised hands. In that case, we'll move on to the next presentation, which will be made by Mr. Charles Hundo, who is head of the Formality Examination Department of the African Regional Intellectual Property Organization. Mr. Hundo has responsibilities for receiving and processing of all new applications on patents, utility models, and industrial designs under the Harare Protocol and marks under the Bunjul Protocol. He is holder of a Bachelor of Arts degree in English and Communication Studies and a Master's degree in Intellectual Property. Mr. Hundo, welcome.
Thank you very much. Good afternoon, good morning, all. On behalf of my Director General, I would like to thank the CarIPI Directorate for inviting a report to participate in this very important webinar. I'll start sharing my presentation. My presentation will dwell around the historical background of the organization, the membership, and within that will be the reasons for establishing the organization and the structure of it, but we'll dwell much more on the trademarks other than the other domains or fields the office handles. The idea of forming the organization was mooted well back in the 70s, and this was during some WIPO meetings and UNECA meetings, that's United Nations Economic Commission for Africa meetings, seminars and workshops for English-speaking African countries. This was on the background of the colonial legacy. During those days, a number of countries were attaining independence, and on attaining independence, they faced a number of challenges, which included poor IP legal regimes, non-homogeneous IP IP regimes, dependent IP regimes, outdated laws, non-existent IP laws, and dual systems, and poor IP infrastructure, and poor public awareness on IP matters. This is one of the drivers for the establishment of the system. It was also realized then that it was very costly for these states to pursue IP administration on individual country basis. So they had to think of finding a way around it. So states then decided to pull resources together in order to avoid duplication and financial and human resources, and formed the organization. We have there a slide on the current member states of the organization. To date, there are 20 member states who are party to the organization. I would like to point out that our latest state was Mauritius, which just joined last year. We also have what we call potential member states. These are states which participate in most of our activities and have shown interest in joining the organization. And that interest is at different levels for those states. The structure of the organization is we have governing bodies. The governing bodies, we have the Council of Ministers, who are the policy and political organ of the organization. Usually these are ministers who head ministries responsible for intellectual property in each state. Then we have the Administrative Council, which is the organ composed of IP heads, heads of offices responsible for intellectual property in each state. Then we have a number of technical committees which are responsible for different mandates. We have the mandate on industrial property, on copyright, plant varieties, the finance committee responsible for our finances. Then we have a committee on staff affairs. We have an audit committee. Then we have another separate sort of independent body, which is the Board of Appeal. This at any point is composed of 5 members from the member states, and it always looks at decisions made by ARIPO where the applicant thinks ARIPO did not conduct them properly. They can bring that to the Board of Appeal. Then to do the daily activities, we have the Secretariat, which is headed by a Director General. We also have cooperating partners whom we work with, and this is in accordance with our forming agreement, which is the Lusaka Agreement, which gave direction to the creation of the organization. So there's an article in the Lusaka Agreement which allows the organization cooperate with WIPO and states not members to ARIPO and with other organizations, institutions, and bodies. I've just listed a few cooperating partners. We have regional offices like the EPO, OAP, UIPO, EAPO. We have national offices we have cooperated with in a number of activities: UK Patent Office, Chinese Patent Office, in Portugal, INPI Brazil, the Swedish office, USPTO, we have KIPO, and the JPO. These are just among those other states we have cooperated. We have institutions and other organizations from mostly Africa. We have the AU, the ASO, COMESA. These are regional organizations. Of late, we have heard of the AFCATAF organization, which we are moving on to cooperate with in terms of trade and IP. The main objectives of the organization on inceptions were to promote and harmonize, that's promotion and harmonization and development of intellectual property, to establish common services and organs for IP coordination, development, and harmonization, to establish capacity building schemes, promote exchange of ideas and research on IP, promote a common view in dealing with IP matters, support member states in acquisition of IP-based technologies and development of IP system for the economic benefits of the member states. This information can be found in a document, the Lusaka Agreement. It lists all the objectives. The mandates covered by ARIPO, currently we have 3 of them, mainly 3. We have the mandate on industrial property rights, and this covers patents, utility models, industrial designs, marks, and geographical indications. We have the mandate on copyright and related rights, and another mandate on traditional knowledge expressions of folklore and genetic resources. To implement these mandates, we have in place 4 protocols, and these are the Harare Protocol on Patents and Industrial Designs. This also caters for utility models. This protocol also is linked to the Patent Cooperation Treaty, so that the receiving office for PCT applications, and can also be designated on PCT application. In actual fact, almost 90% of our applications, patent applications, are PCT based. Then we have the mandate on marks under the Banjul Protocol. It was signed in the capital city of the Gambia, and that's why it is named the Banjul Protocol. You also notice that the Harare Protocol is named so because it was signed in the capital city of Zimbabwe. Then this caters for marks or trademarks and service marks. It has the mandate to administer this. I will be talking more on this other than the other mandates. We have the Swakopmund Protocol on the protection of traditional knowledge and the expressions of folklore. We have a number of states now where it has now become operational, but we are yet to receive meaningful applications on TK. Then we have the Arusha Protocol for the protection of new varieties of plants, and this is yet to be operational because not enough states have acceded to the protocol for it to be operational. On copyrights, we are planning a diplomatic conference this year, which will be held in Uganda, Kampala, Uganda, to probably come up at the end of the day with a protocol on copyrights. This slide just gives the status of the main 3 protocols which are operational. I mean, the 2 protocols and the agreement. For a state to be a party to a new state to join the organization, they have to sign the Lusaka Agreement. Then they now also join the protocols for that mandate on type of IP to be administered by ARIPO. So we have 20 states which have become party to the Lusaka Agreement, and of those 20, 18 are party to the Harare Protocol, and 11 are party to the Banjul Protocol. Fortunately, I did include the one on the Swakopmund Protocol. It has 8 states which have become party to that protocol at the moment. So this means that we can receive applications designating all those countries, 18 countries, on patents, industrial designs, and utility models. And also for Banjul Protocol, we can receive and administer applications to the trademark applications, which covers 11 countries at the moment. This is just snippets of the applications we have received so far, within the organization. We don't boast of big numbers in the organization. Since inception, we have received about 1,500 designs, and these designs will be designating different countries. Then we have about almost now 13,000 patent applications. Marks was about 4.3, then about 100. I think now we are at about 100 and 200 utility models. Now I will talk more about the Banjul Protocol, which is the protocol on trademarks. This was adopted in 1993, and it entered into force in 1997. It empowers ARIPO to register and administer trademarks on behalf of the member states who are party to that protocol. It accords regional protection, form of applicant indicating the states they want to seek protection for on an application. The duration, is the 10-year renewable, just like any other in most of the countries. Out of the 19 member states, I'm sorry, it should have been 20 member states, 11 are contracting states to the Banjul Protocol, and those are the states. I've put Mozambique there in red because Mozambique, although it has been one of the long-standing member states, it only became party to the Banjul Protocol in August 2020. That is the geographical representation, the area which we cover in blue for trademarks. We have here marks filed on yearly basis. We have been having a gradual, increment very difficult to predict. You find 1 year is going down, the other is going up. As an office, we are trying to engage our minds on this and see how we can address this and have sort of some predictable, filing of applications within the organization. You'll find that the peak in 2019 was the highest we have had in terms of applications filed, and it is in 2020 it went down. We are tempted to think it's because of the COVID, but we will have to see whether it will maintain that trend. Most of our applicants, and maybe I can put some more information on that. Most of our applicants, in terms of trademarks from the host country, we have Zimbabwe as the highest contributor of trademark applications under this system. Then these are followed by South Africans who are not members of the organization. Then we have the Americans also in the top 5, users of the system. We have a designation system where each, when filing an application, the applicant chooses. It's not a unitary system. The applicant chooses the country, has got the choice on which countries they want to designate. You will find that these are the designations we have had for each member state since 1997. You find, like I said, Zimbabwe has the highest number of designations, mainly because most of the applications, and the Zimbabweans contribute a higher number of applications filed under this system. One other aspect I maybe need to mention here was the slowness in some of the states in domesticating the protocol, because it's a requirement that when states become party to this system, they need to, where applicable, domesticate or reflect that, they have that reflected in their laws for enforcement purposes. So you find that some of the states have been slow in that because applicants are a bit hesitant to designate those states. What have we achieved so far? We have become the driving force for development in IP in the member states. We are always consulted. We are always there when it comes to IP matters. We have seen a number of, over the last few years, a number of accessions to the ARIPO system. And we have also seen a number of countries domesticating, understanding the need to domesticate their laws to include ARIPO, the ARIPO system in their laws. Assurance in enforcement matters. We have seen a number of the registrations growing up, although I have said they are unpredictable. We have been assisting member states in the development of IP policies. This has been one of our major activities during the last few years. We have also established a master's in IP together with WIPO and universities in Zimbabwe, one in Tanzania and another in Ghana. And for the university in Zimbabwe, we are now in the 13th year, or the 13th cohort. For Tanzania and Zimbabwe, they just started recently. In Tanzania, we are in the 2nd, and in Ghana, we are in the 3rd cohort. We also do training of staff members, training of staff from IP offices and examiners from IP offices. We do a lot of awareness raising programs for our member states, and were involved in the modernization of ICT infrastructures through a project we had with the Korean IP office. It was called the CarIPI project, and this brought our system, our administration system we use at ARIPO and all its member states. It was launched in 2015, and now it is undergoing restructuring, upgrading of the system to cater for other activities, because it has actually become very popular with our users. The system has got its advantages. These are usually found in any organization of this sort. An applicant can file applications either with the national office, directly with the ARIPO office. I want to mention here that because supplement to the national office, it does not remove the need to file application through a national office. So applicant has got choice. They can file through the ARIPO or through the national office. They can choose to designate states they want. They can pay in one currency, in US dollar. Applicant can engage only one agent, attorney, to file the application. There is centralized processing of the granting, the registration, granting, and renewal of IP rights. And it also allows for conversion of an application where it has been refused at a repo. An applicant can convert it to a national application without losing the filing date. It is very simple and cost-effective and user-friendly. In actual fact, every year we conduct what we call a working group where we invite all users from the member states or even beyond to a session where we aim to improve the functions of the protocols. And it is becoming very popular this because it allows everybody to contribute to the system. You can also note that it has low cost compared to individual filings. Challenges we have faced so far include lack of centralized trademark examination. The system requires that each designated state conduct its own substantive examination according to its national laws. And this sometimes creates some delays. And we also realize this is mostly a duplication of the work. So that is a challenge we have. Then we also have a challenge of harmonized national laws. Here and there you find we have requirements which differ from one state to the other. The lack of common territory or jurisdiction is the reason why you find that ARIPO is not party to the Madrid system, is not party to the Hague system. So these are some of the challenges. We think if with this, we could offer better services for our users. We have had a slow accession, but although ratification by member states to the protocols, although we have seen of late a number of states changing their laws to do that. And that also includes the domestication by member states. This, ladies and gentlemen, is a photo of our offices in the outskirts of the capital city of Zimbabwe, Harare. And for those who have the chance to visit it, this is just a glimpse of it. And with this, ladies and gentlemen, I come to the end of my presentation. Thank you very much.
Thank you very much, Mr. Hondo, for that presentation, which has given the region or participants much to think about with regards to how a regional IP system can be established, the functions, the challenges, etc. In terms of questions, I don't at this point see any questions posted immediately, so we can move on to our next presenter is Ignacio de Miranda Caballero, who is head of international cooperation at the EU IPO. Ignacio is a lawyer and specializes in intellectual property. He joined the EU IPO's office in 1997 as a member of the opposition division. He has held several managerial positions at the EU IPO as deputy director in the human resources area in the general institutional affairs and external relations department. Between 2014 and 2019, he worked in Bangkok, managing international cooperation programs of the European Union with ASEAN on intellectual property. He currently holds the position of head of international cooperation services in charge of cooperation activities and relations with non-EU countries. Also the management of EU-funded programs. In particular, there is also the TM5, the ID5 countries, and activities in relations to WIPO and the European Patent Organization. Ignacio, welcome, and the floor is yours.
Thank you very much, Wendy. Good morning to my colleagues in the Caribbean and good afternoon to my colleagues in Africa and in Europe. It is a real pleasure to be here in CarIPI again after just a year that I participated in the last physical activity that I have the opportunity coming to Barbados in fact to open and kick off this program. It was at the end of January and I didn't have the opportunity to have any more professional traveling after that. We all know because of the situation, but it was a real pleasure to start this project and to continue now with this activity. Let me start before kicking off just to also to thank the colleagues from other regional offices who are participating in this activity. I'm really thankful, my colleagues and friends friend Andre and Charles, that I also had the opportunity to visit on the slides that you have seen the offices just about a year ago to Moscow and Harare, and it is a real pleasure to meet virtually here. Hope to see you soon in any of the locations that we have seen after this will pass. Let me talk a little bit about our system, about the EU IPO, and I also wanted to share a little bit with you consider the ASEAN experience. These 5 years that I spent in Southeast Asia gave me a little bit of insights of what are the efforts that the ASEAN member states, that the ASEAN countries are taking in order to try to integrate themselves on intellectual property, and maybe this is something, or their experience might be also interesting for the CARIFORUM states. Next slide, please. Here a little bit of history, chronological history of how we achieved the existence of a European trademark design. Just to let you know that, the first studies or the first analysis about the benefits of having a common trademark or a common design for what it was called at the time common market and European Union nowadays started just a little bit later than the common market was set up in 1957 by the Treaty of Rome. It was on 64 that they considered that for having, in order to achieve this free flow of goods and services, that it was one of the principles to set up a common market in Europe. It was a very beneficial to have a common trademark. So discussions started by the member states at the time, 64. It took many years for them to negotiate and to achieve some results. And this result was, in fact, the approval by unanimity of the 12 member states that they were at the time in 1993 of the regulation establishing what it was called at the time community trademark, nowadays European trademark. And at the same time to set up a body, an agency, the one I work with, OHIM at the time, Office for Harmonization on External Market. We changed our name a few years ago to become the European Union Intellectual Property Office. Next slide, please. So the way in which it's been considered that the system should be set up at the European Union, it was from the very beginning based on the principle of coexistence. The fact that we had trademark that could be used in all the member states of the European Union wouldn't, according to the discussions that took place at political level at the time, wouldn't lead to the elimination to not having any more national trademark. This is something that it is considered useful to have the choice for any company from all over the world to decide if they prefer to go for a national protection, they are not going to export to the whole community or European Union, or to go directly to our office in Alicante in Spain and registered automatically for the nowadays 27 member states since 1st January this year. At the same time, we've been also considering that, and this started in parallel on the creation of the European trademark, that it was necessary to harmonize as much as possible the national laws. This coexistence, in order to avoid misconceptions and different ways of treatment between the national trademarks and the regional, lead to have some substantial elements of the laws of trademarks and then afterwards on designs harmonized among all the different member states. This is also done finally also by the way of the interpretation that it is given by the European Court of Justice placed in Luxembourg, that has always the last word on how we on administrative proceedings in the EU IPO interpret and have the decisions taken. Of course, anyone can appeal to the European Court of Justice on the decisions that we take in Alicante. And at the same time, all the courts related to national trademarks have the opportunity to use something that it is a mechanism that it is called preliminary ruling in order to ask the Court of Justice in Luxembourg to interpret any provision of substantial law in this harmonized legislation. The harmonization of the national laws is at the same time harmonized with the, let's call it, federal law or the regional system of managed by the EU IPO. Next slide, please. So here you have it a little bit, this harmonization of laws. At the same time, something else that we are trying, and this is something that has been also, I think, part of the initiatives taken in the framework of the CarIPI program to try to harmonize practice, or at least to converge in the practice. Even we realized in the European European Union level on the member state that even if we have, let's say, almost identical provisions on the legislations that we had, the practice of the offices interpreting this, even if it was harmonized at the same time, as I said, by the Court of Justice, there was some mismatchings on the way it was done by the different national offices and the UIPO. So we are trying with guidelines, with soft law in some way to converge and to arrive to same results on similar or identical cases that are placed in the different offices. Next slide, please. At the same time, we are helped by, in this work, with tools we have developed in order to, in some way, give some assistance to the users of the systems, and at the same time to arrive to common results on, just to give an example, on similarity on goods and services using the databases that we have on previous cases that have been handled by the different offices, and in order to be consistent in the decisions that we take in the future. Next slide, please. So a few words on figures. Nowadays, on 20 last year, even with the situation that we face, there's been almost 176,000 applications to European trademarks at the Alicante, and 115 community designs. There is a slight growth on the number of applications from 20 compared with the previous year. So this is something that it was a little bit of a surprise for us after some drop in the first months of the year. Then we have this growth. What are the competences of the EUIPO today? Is to register these community trademarks or European trademarks, and community designs. So we are a registered office. At the same time, we have some competence given by us, by the European Union, on what it is called the Observatory on the Infringement of Intellectual Property Rights. This is, put it like this, coordination of enforcement agencies from the member states. The European Union has no competence as such on enforcement, but we facilitate the work of the different forces that have some competence on enforcement, the judiciary, the police, customs authorities. So we try to coordinate and to facilitate the job as regards intellectual property, and we provide with the studies. This is also important in order to analyze the importance and the relevance of intellectual property, or analyzing a specific sector on how infringement is damaging when we go to intellectual property infringement. Finally, international cooperation. This is something that we are doing with the programs that we are running, and this is a competence in order to try to promote as much as possible intellectual property and to converge in the practices worldwide. Next slide, please. So what are the benefits they've been seen from the very beginning? As I said, we tried, not even if it was created more than 20 years ago, the system of European trademark. In fact, it was set up at the very same time that the EIPO system was for patents was developed. But after some years, we considered that it was important to do a study, or the Commission needed to assess the efficiency and the effectiveness of the system. This took place in 2011 with a study that it was developed by the Max Planck Institute in order to see if some adaptations needed to be done in the trademark system in order to adapt it the years that have passed. And this took place. We have a reform in 2017, adapting or modernizing in a little bit the system as it was created for some of the elements that were identified by the study. Currently, we are doing the same thing with the system of designs, that it was set up in 2003, and nowadays the Commission is running or is discussing about a possible reform in the next years. There's been an action plan on intellectual property just adopted by the Commission at the end of last year, in which this modernization of the design system has been put as one of the priorities for the next years. Next slide, please. So just let me go very quickly to the ASEAN experience, on which because of the, let's say, the mechanism and the institutional framework that they have, it's a little bit different from the European one, because there's no, of course, the same institutions. They have some similarities in some of the elements that they have, like the creation, or one of the scopes was the creation of an ASEAN common market, and this was took place very few years ago. But at the same time, they've been working together, the 10 ASEAN member states, the currently 10 ASEAN member states, almost 1996, in trying to arrive or to reach some common goals in intellectual property. It was created what is called the AWGIPC, ASEAN Working Group on IP Cooperation, that it is composed of the Director Generals of the 10 ASEAN IP offices. And at the same time, they were adopting some actions plans since almost 2000, in which some objectives or some possible projects together were put on this action plan. One of them from the very first plans was to set up an ASEAN trademark. This was considered, even if an important achievement, but at the same time, it was difficult to reach by at the time. There's been some attempts. I said it was considered in some way too ambitious. Now in the last actions plan, the current one goes from 2016 to 2025. The expectations have been a little bit lowered to say, okay, first we need really to arrive to some kind of convergence in the practice of that we have between our countries. But at the same time, this final objective maybe can be achieved. As I was always telling to them when I was in Southeast Asia, this is normal. I mean, in Europe, it took us more than 30 years to reach an agreement among the member states to have a common intellectual property right. So ASEAN is a younger regional organization, and of course they are they're continuing their path, but still some work to be done. One of these things, next slide, please, that it's been considered nowadays a possibility is first to analyze what could be, how this system could work. And there's currently been a feasibility study that it is about to be finalized on the creation of an ASEAN trademark system. And this has been analyzed by experts, two very senior and very prestigious experts. One, it was a former director general of the Singapore IP office, and the second one is a professor that it was in fact one vice president of the EUIPO some years ago. These two experts have been analyzing the different elements that will be needed and what could be the benefits to set up a system in ASEAN. And this feasibility study will be discussed among the IP offices when it is finalized, that it will be done within this year. So with this, just to share with you a little bit the European experience and the ASEAN one, that are a little bit different, but at the same, because they are on different realms and on different timings. But at the same time, I think maybe it can be from some inspiration for any idea of creation. What I would like to convey to you is that I am a firm believer of the regional systems. I think they are good for the companies. I think it is something that provides a possibility for any user from all over the world to try to have protection in a given region. I think the three examples that we have presented today from different parts of the world is very good examples of what could be also, of course, a system if it is considered appropriate in any region, and in particular in the Caribbean in the future. Thank you very much.
Thank you very much, Ignacio, for your presentation. Basically raising the awareness of regional systems and bringing that to the fore. And in addition to those regional systems, also, I think what was important coming through from your presentation and the other two was the importance of actually these regional offices being spearheading the studies to get the information and the statistics that are useful for decision making when it comes to deciding on developing these regional systems and how they can actually work. Thank you very much. I think we'll go straight to our next presentation. If we don't have any questions, there's a question from Malcolm. I will reserve that question for after our next presenter, which will be Rachel Jones from Snapdragon, who is the founder of Snapdragon, which is a monitoring and brand protection agency, which is based in Edinburgh, Scotland. Rachel actually started this company after her own product was counterfeited. So she actually, she's felt personally pain that comes with actually having your product copied on the market and having the fakes put on the market. Now, her company, Snapdragon, works with SMEs around the world protecting their brands online. She's a member of the EUIPO SME Task Force and the Scottish Government's Trade Board. Snapdragon also received the Queen's Award for Innovation in 2020. Rachel, welcome, and we look forward to hearing your experiences as an SME within operating within the EU framework.
Thank you very much, Wendy, and hello, good morning and good afternoon to all. Thank you very much for inviting me to participate in this fascinating webinar. And I would just like to take the next 10 minutes or so to talk to you about my story and my love of IP. So we've all heard and we all know that IP has a really valuable part to play in growth. But this statistic from the EU IPO I find quite eye-watering, and it's really what drives me to suggest to anybody who comes to me saying they have an idea to take a product to market to say, please, please, please register your intellectual property, perhaps start with your trademark in your home country, but also possibly also in China. I really believe that if you love your IP, it will fight for the growth of your business. And in a minute or two, I'll tell you exactly why. But what is also important to remember about IP, particularly as an SME, is exactly what everyone has been saying earlier on today about regional systems can be super efficient and effective, particularly when you have limited resources. Believe me, I am Scottish and I don't spend money when you don't have to. And I certainly wouldn't have had the resources to do what Helen's earlier example was talking about, much as I love the concept. So as you all know, until recently, the UK was part of that wonderful entity, the EU. And before that, we were able, instead of just having rights protected on our own island, to file European rights, protecting us in those 27 member countries with just one filing. I am not a linguist and I don't speak 23 languages. So for me, using the European system made absolute sense, both for trademarks and for design rights. It saved me working with the 27 individual offices and worrying about languages. Of course, now, unfortunately, life has changed. However, for people who have the opportunity, it's wonderful. And as was mentioned earlier on, for those in Trinidad and Tobago, you can use the Madrid system to protect trademarks in all of the 122 territories of the system and other 106 members by filing a single international application and a single set of fees. And then there's a repo for the African states and several others, as have been mentioned earlier. And I am not an expert in any of them, but I do believe that the benefits of regional systems mean extending your trading reach and being protected as you do so. So this is the real life example of why I did what I did and now what I do, applying my European rights. So some years ago, many years ago now actually, I invented this baby product that you can see in the photo. It's a washable, squashable high chair for babies who lunch. It anchors a baby in an adult chair when you're out and about, or if you don't have room for a high chair. And before launching, I thought I knew a little bit about IP, but I learned a lot just from the library, to be perfectly honest. And I filed both EU trademarks and EU design rights, amongst others. And thank goodness I did. We were ripped off big time. And this is just one example in this slide of a Spanish ripoff, but the European design rights enabled me to take action both online and offline. And actually, in the first case here, we started by using copyright and then design rights, because as you can see, the trademark is not being used. Unfortunately, things got worse and the brand was seriously counterfeited. And the first time I knew about it was when the product was seized by HMRC, which is our the border force, seized some tot seats because I had used what used to be the CITEX system, but is now the wonderful EU IPO application for action system. And because I had registered my small product and we only imported in part containers with 3,000 units, when a box of 36 units came in different colours, the Border Force Agency realised that they were fake, and thus began my journey of learning how to protect myself, my business, my employees, and my family's future against all the things that come with counterfeits. So we have actually used our intellectual property to protect almost everything about the product. We've had trademark infringement, we've had counterfeits, we've had design and patent infringement, and we've had copyright theft, both for images and for words. People even have chopped the top off the baby in photographs and added their own babies and tried to resell the product. So, I mean, it is a horrible, horrible thing to happen to you. But I was pretty cross when this happened to me, and I went off to Alibaba to learn what to do. And that is why I do now what I do. And I think one of the things I would say that if you do have a product which is ripped off and you see that you have counterfeits or problems with very similar copies, unfortunately, what you see will be absolutely just the tip of the iceberg, and you will need to do something about it. And if you've registered your IP, you are in a much, much stronger position to do that. So I really believe that if you have good IP, it will help to protect your business and to win fights online. What I did with mine when I saw the fakes was I went to China. I'm not suggesting everybody needs to do this, but I literally got on a plane and went to Alibaba, which is where I could see the fakes were being sold online. And I talked to Alibaba about what they needed to do to help SMEs. And it does now mean that you don't have to have a Chinese trademark to take action against fakes on Alibaba and AliExpress. You do on other Chinese platforms, but you can use intellectual property which has been registered in your home territory to defend yourself on those too. And that's incredibly important. And it has actually been a bit of a game changer for many, many brands around the world. So I believe that good IP wins fights online. And I also believe by putting that jigsaw together, here's our heart with a couple of boxing gloves, that if you look after your IP, it will look after you and it will fight those corners that it needs to for you. So it was my experience with Totsi which led to Snapdragon, and we now work with businesses of all shapes and sizes around the world to protect them online, and we just use intellectual property to do that. So we use people's intellectual property to prove originality of that product online. It's a cheap and efficient way of doing things, and it does mean that you don't always have to involve lengthy court processes. Of course you can, and you can go on to that, and the data that we collect does that too. But if you're an SME with issues online, the first thing you want to do is remove the public visibility of those fakes so they can't be purchased and imported and distributed locally. I was absolutely horrified by the processes, the length and everything that 10 years ago was being used. But now intellectual property is a real force that businesses, small and large, can use to protect themselves and to grow. The saddest thing for me now is when people come to me, particularly if they've gone through a crowdfunding exercise and they don't have any IP, but their brand or their trademark is already out there, and actually they get ripped off before they're able to land the original product. It's incredibly sad, and for a wee bit of money and a little bit of foresight, they would be much better protected. So protecting your brand should not cost the earth, but protecting it regionally will give you the opportunity to explore it. Thank you.